All right. So Matt said that hopefully I'd be around for the next sunset. And unfortunately, my term ends next February. So I'm at the end of my second term. We have 2-term limits. And so I will not be around for the next sunset. So we need more of you guys to be involved and be prepared for that one. So for tonight, this is the 4th in a series of ethics presentations that I've done. And as you can imagine, I have to look around and try to find things to talk about. So this one may be a little bit different than some of the other ones that I've done for you guys. So I like this quote: "History shows that where ethics and economics come in conflict, victory is always with economics. Vested interests have never been known to willingly divest themselves unless there was sufficient force to compel them." That one just made me chuckle. But getting ready for this one, I was really searching for ethics topics, some things that I felt like we could talk about that would be of interest. And so I did a little quick search and I found a website that was dedicated to providing topics to students for ethics essays. And, you know, I found some of the usual suspects. Can we justify eating meat? Is it unethical to be extremely rich? That kind of thing. But then I found a couple of others that were a little interesting or perhaps surprised me. One of which was, can torture be justified? And then the last one on this list was, can anything, technology, politics, laws, policing, etc., be truly transparent or private? And that really kind of led me down the road to what you're going to see tonight. So I started looking at the concepts of transparency versus privacy. And on the transparency side of things, there are disclosure requirements, there are corporate regulations, there's information that has to be shared due to regulations and laws. But on the privacy side of things, we like to think that our individual data is private and that there are regulations out there that are protecting our privacy and data misuse. So with that, I kind of started looking at the internet, right? It is the basis for commerce, work, entertainment, healthcare, learning, human discourse, continuing education for TBPG, and it's led to an ever-increasing volume of data. And so I found this quote that I thought was really interesting. So between the dawn of civilization and 2003, we had put 5 exabytes of data online. And so 1 exabyte is 1 times 10 to the 18 bytes, 1 quintillion. But today, 5 exabytes of data are collected every 2 days. So it's pretty shocking and pretty staggering to think about the amount of data that is actually being collected and that is out there for us. We have unprecedented access to information, especially about corporate behavior, operations, and performance. Stakeholders, citizens, and investors now scrutinize firms like never before. They've got information at their fingertips and they can organize collective responses. Employees now share things that were formerly secret about corporate strategy, management, and challenges. We have instant communications. We have whistleblowers. We have inquisitive media, and of course, the ever-present Googling. So the upshot on all of this data is that business integrity is actually on the rise. Ethical values and transparency can make a company more competitive and more profitable. And transparency is no longer just an obligation to report. It really has turned into a new competitive force that creates trust and loyalty with staff, customers, and shareholders. But of course, there's a downside. And the downside, in my opinion, is privacy. A large part of the privacy that we've enjoyed has really been due to anonymity. We weren't tracked. Our comments weren't tracked. Our thoughts weren't tracked. Our data searches weren't tracked. But now we give away our privacy every time we use a computer or a phone. And there is no safe data repository. If you look at the theft of personal information from 41 million consumers at Target, 147 million Equifax consumers, 500 million Marriott customers, 3 billion Yahoo accounts, right? So privacy in the manner that we've known it really doesn't exist anymore. And we have the potential for employers now to be scrutinizing us. They can find out how much you drink on the weekend when you're posting on Facebook. Insurance companies can use that data to decide how much to charge you on premiums. And banks search your information when they're making loans. So privacy, in large part, is gone. But the right to privacy was articulated in both national and international law. The right to transparency or freedom of information is encoded in our national laws, especially for governments, but it's still lacking internationally. But that means that corporations, federal and state government are required to be open. Some of the good news is that all of this open data has resulted in the growth of open access and citizen science movements. But you may be thinking at this point, what has all of this got to do with me personally? So it's not just the corporations that are creating that 2.5 quintillion bytes of data every day, it's really us. All aspects of our lives are observable, linkable, and archived, so they are forever searchable. And most of that data is controlled by third parties. So some of these facts were staggering to me. Every minute of every day, Snapchat users share 527,000 photos. 120 professionals join LinkedIn. Users watch over 4 million YouTube videos. 456,000 tweets are sent. Instagram users post almost 47,000 photos. 600 new page edits to Wikipedia, 16 million text messages every minute, 990,000 Tinder swipes, 156 million emails, 103 million spam emails, 154,000 calls on Skype, and Venmo processes almost $52,000 of peer-to-peer transactions every minute of every day. So in 2019, the American Management Association conducted a survey, and they found at that time that 66% of organizations were monitoring internet connections, 45% were tracking content, keystrokes, and time spent on a keyboard, 43% were tracking the storing and reviewing computer files, 43% monitor employee emails. And so the question that came to mind with that for me was, then how can a company build trust and loyalty with its employees when surveilling them in this manner? And the answer, of course, comes back to transparency. So according to that same survey, about 84% of those companies actually tell their employees that they are reviewing computer activity. Now, most businesses don't have people sitting around reviewing your activity every day just to see what you're up to. However, if they suspect that you're not as productive as you should be, they may begin to monitor you. That's when that monitoring typically kicks in. So there's also a lot of employee monitoring software out there that allows employers to view every file you access, every website you browse, and every email you've sent. Deleting a few files and clearing your browser history does not keep your work computer from revealing your internet activity. So in recent years, surveillance has really escalated. So companies are collecting, selling, and analyzing and combining personal data on a large scale. But most of that data is being collected by third parties, and a lot of it is to assess behavioral and health information. Pardon me. They can also then apply analytics to a range of consumer data like grocery purchases, location information, and they can generate actually health inferences like a risk of depression or diabetes, which is how this plays into what insurance premiums can be, health insurance premiums can be. So there's a lot of questions regarding the ethics of this corporate surveillance to create these health-related databases, if you will. And then the larger question is, should we be gathering this type of information to address urgent public health issues? Do we go beyond our right to privacy to address public health? So another example, in 2019, Facebook debuted an AI tool to identify posts indicating a high risk of suicide. So the tool development followed a number of incidents where Facebook users had posted suicide notes or live streamed suicide attempts. And there were a lot of critics for this AI tool. They pointed out areas of ethical concern, including that the tool could be considered medical research, but it doesn't give the protections that are generally required of research, such as consent or accountability. Facebook's suicide prevention tool does not allow users to opt out. And so information regarding the accuracy of the algorithm or the outcomes of their process for interventions are not available for outside information, outside observation and evaluation. So it's been kind of interesting in pursuing this. So in response to these privacy issues, two what we would consider adversaries have partnered. So Apple introduced a pop-up window for iPhones that asks people for their permission to be tracked by different apps. Apple's position is they believe privacy is a fundamental right, and they don't collect user data for personalized ads, but and they say they don't track across what you do across third-party apps and websites. But Google allows you to disable tracking technology in the Chrome web browser, but Google is the world's largest advertising platform and one of the largest collectors of user data. Google now pays Apple $15 billion a year to be the default mobile browser. This means that Apple, who believes in right to privacy and not tracking you, is funneling their users directly to Google, who's the world's largest advertising platform, and they then are able to monetize your searches, shopping, and activities. And almost no one changes this default on their iPhone. So we're experiencing this profound shift in how personal information is used online, and it has some sweeping implications for how businesses make money digitally, actually. More than 20 years ago, the internet drove an upheaval in the advertising industry, killing newspapers, magazines, and print or classified ads. It also threatens to dethrone television advertising as the prime way for marketers to reach large audiences. So now, big business is buying digital advertising through cookies, and that's how your activities are tracked on your phone or computer. And they're earning exponential profits by selling that data so you can be targeted with relevant marketing. The digital advertising industry is now $350 billion. So the ACLU dedicates a lot of web space to these kinds of issues. So technological innovation has outpaced our privacy protections. As a result, our digital footprint can be tracked by the government and corporations in ways that were once unthinkable. They go on to say the digital footprint is constantly growing, containing more and more data about the most intimate aspects of our lives. It includes our communications, our whereabouts, our online searches, our purchases, and our bodies. And the government has easy access to the information, so we lose more than just privacy and control. It has the potential for free speech, security, and equality to suffer as well. Go on to talk about some of the laws that are that were designed to protect our privacy. So one of the ones that they mention is in 1986, the federal law protecting your electronic information. It is therefore older than the World Wide Web. So that law was on the books before we really had internet access. They also talk about the Fourth Amendment that protects information you keep in your desk, but it doesn't protect the information that you keep online, like emails, pictures, that sort of thing. They mention then the National Security Agency and their ability to carry out mass surveillance, and that NSA has actually weakened the security of communication systems that we all rely on. And then they talked about medical and genetic information that can reveal some of your most personal and private data. And medical records are increasingly being digitized, and genetic sequencing is becoming faster and cheaper. So those threats to privacy and autonomy intensify. So that led me down a whole other rabbit hole. And so I don't know how many of you have seen the show Genetic Detective, but it's a series on ABC that follows an investigative genetic genealogist named Cece Moore. And she uses her unique research skills, and she has transformed the face of crime solving. She works with police departments and crime scene DNA. And using that DNA, she is able to trace the path of violent criminals' family trees to reveal their identity and bring them to justice. The Golden State Killer was finally brought to justice using genetic genealogy. And so most of us go, yay, they finally caught the Golden State Killer. but there's a little more to it. So the Golden State Killer was active between 76 and 79-ish, serial rapes and murders across California. And it turns out that D'Angelo, the person who was ultimately arrested, had actually been a police officer in 2 different towns in California. And more than 50 cases went dead for decades with no leads and several different descriptions of the suspect. But DNA from one of the cold case rape kits attributed to the Golden State Killer was reanalyzed using modern techniques. The new DNA profile was then uploaded to a company called GEDmatch. They're an open source platform used by the public to trace their heritage. So think 23andMe or Ancestry.com. So your DNA is roughly 50% similar to each of your parents, 25% similar for grandparents. So for each generation, the genetic similarity is reduced by 1/4. And so when you do something like 23andMe and you post your DNA, it's highly unlikely that you'll find a first or second cousin, but GEDmatch should give you thousands of third cousins. So Cece Moore studied the third cousins found in GEDmatch, and then she did reverse genealogy, calculating the number of generations backwards to the shared ancestor based on the percent DNA match from GEDmatch. Once she got back to how many generations back, she then started using a family tree or building a family tree using birth and marriage certificates and working her way forward in time until she actually identified D'Angelo as the only possible male descendant from that original couple, based on the genetic profile. So it's really quite interesting to see how she works her way backwards, that common ancestor, and then works her way forwards using more traditional genealogy methods. But when she built the family tree and identified D'Angelo, investigators then surveilled him and collected his DNA from a tissue that he left in the trash, and it was a match. So in 2018, D'Angelo was arrested at age 74. In 2020, he pled guilty to 26 counts of first-degree murder and kidnapping and admitted to 61 uncharged violent crimes, including rapes and murders. He was sentenced to life in prison without parole. But some ethics come into play here. There were some facts that were not originally disclosed in the courtroom. First of all, the genetic material from the rape kit was retested, and then it was sent to a company called Family Tree DNA, where they created a DNA profile. Rather than seeking a warrant to search all these DNA databases, law enforcement set up a fake account using that profile to search for matching customers. So the picture I have at the bottom, is it legal? Is it ethical? There's some questions about that. So it turns out that the use of these consumer databases in this manner has sparked a series of ethical debates. So investigators relied on genetic information that people voluntarily made public with little to no reason to suspect it would incriminate members of their family. There were no warrants for DNA information ever issued, and the fake profile violated the privacy policy of at least one of these DNA companies. Most private database users had told their users that law enforcement could access their databases if it was required or if they presented a lawful request. So the fake profile doesn't match those two cases. So today, as a result, most consumer genealogical databases now have created some barriers against this kind of law enforcement access, and they inform their users that the police might only access their information if there's a warrant. So part of the reason for all of that is this Golden State Killer case unleashed a whole wave of efforts by other cold case teams to do the same thing. And since D'Angelo's arrest, there's been over 150 other suspects that have been identified through this genetic genealogy technique. And just yesterday, I ran across this story, how they're doing the same kind of thing with illegal ivory trade in the Philippines. They're taking squares of ivory cut from confiscated elephant tusks. They're sending them for DNA analysis, and then they're comparing them to DNA from previous seizures, which would suggest the same criminal organization was involved. And they're comparing them to tissue and scat samples from known forest and savanna elephants so that it can approximate the geographic origin of the illegal tusks and identify critical poaching hotspots. So pretty fascinating stuff. But all of that kind of brings us to accident versus intent, right? So our ethics, are they accidental? Are they intentional, right? And so accidental things happen by mistake. Intentional, it's planned or it's done on purpose. So with that, I wanted to give a couple of stories, just a couple of little things to make you think about accident versus intent. So most of you are familiar with Easter Island, 64 square miles in the South Pacific Ocean, 2,300 miles off of Chile's west coast, discovered by the Dutch in 1722. Their oral traditions state that the first people arrived on Easter Island, or Rapa Nui, about 900 years ago. At that time, the island was covered by a subtropical forest, including the largest palm tree on record. The population rose to thousands. They formed complex societies. They carved over 1,000 moai, the stone statues that they're famous for. The largest one was over 70 feet tall. But as the population grew, the demand on island resources grew exponentially. 23 tree species became extinct. All land bird species were eaten. 26 of the 27 seabird species were eaten. Speculation is that they actually became cannibals to survive. There's some archaeological evidence that supports that theory. 90% of the population was gone and the society had collapsed by 1670, 1680. Island traditions claim that around 1680, one of the island's two remaining groups, known as the Short Ears, began a civil war against the Long Ears, burning many of them to death on a pyre, toppling the moai, and fighting with obsidian spear points. So Jared Diamond illustrated the reasons behind the collapse of these societies on Easter Island. And he said, first of all, humans hammer their environment. It's the destruction of most life-sustaining species, right? Second was climates are changing, both short and long-term changes. And then three is society's response to the challenge and the change. And so my question then is, did the inhabitants of Easter Island really intend for their society to collapse, especially in this manner? So accident versus intent. The other story I like to talk about a lot with my students is the Dust Bowl. Here in the US between 1930 and 1940, several waves of severe drought, and some regions experienced drought conditions for as many as 8 years in a row. So many farmers had bought land in the Great Plains in the arid grasslands, and they had paid as little as $5 an acre for some of those regions that were not well suited for farming, those areas that are getting less than 10 inches of precipitation a year. But mechanized farm equipment allowed us to convert 5.2 million acres of thick native grassland into wheat fields. This was called the Great Plow Up. We displaced the native deep-rooted grasses that normally trapped soil and moisture, and the unanchored soil turned to dust, blown away in huge clouds called black blizzards, often reducing visibility to less than a meter and reaching as far as New York City. About 850 million tons of topsoil blew away in 1935 alone. To put that in perspective, it's 150 times the weight of the Great Pyramid at Giza, or equal to the weight of about 5 million houses. One storm that lasted 2 days in May of 34 deposited 12 million tons of dust in Chicago. Black Sunday, the worst dust storm of all, was on April 14th, 1935. The storm carried twice as much dirt as was dug out of the earth to create the Panama Canal. The canal took 7 years to dig. The storm lasted a single afternoon. We lost more than 300,000 tons of Great Plains topsoil that day. So the drought and the erosion of the Dust Bowl affected 100 million acres across the panhandles of Texas and Oklahoma, New Mexico, Colorado, Kansas. It was the largest migration in American history. 3.5 million people move out of the Plain States, and more than 7,000 men, women, and children lost their lives to dust pneumonia. So again, did the inhabitants in the Great Plains really intend to create the Dust Bowl? Accident versus intent. So our response was that Congress created the Soil Erosion Service, now the Natural Resource Conservation Service of USDA, to administer an erosion control program. They provided some financial incentives for farmers to take unsuitable lands out of crop production. They implemented new practices like terraces, drainage outlets, contour plowing, and crop rotation. And by 1938, blowing soil was reduced by 65%. We had another severe drought in the plains in the 50s. It was actually worse than the one in the 30s, but it failed to produce the dust storms of the same magnitude. So since 1935, we spent $30 billion on erosion control in the US. Oh, in the previous two examples, it's clear that adverse consequences were not intended. And so my question then, has this ever happened to you? Have you ever been in a situation where you didn't intend to have adverse consequences, but something went wrong and it happened anyway? And how many times have you heard the old adage, the road to hell is paved with good intentions? So when we talk about disaster and collapse, these are generally as a result of a series of decisions rather than one single bad decision that we can point to. We get some different types of thinking involved. We get some false reasoning. We get failure to actually perceive a problem, that creeping normalcy, and taking no action after we do recognize that there's a problem. And then another complicating factor is societal structure limitations. If the elite insulate themselves from the consequences of their actions, they will not take action. And then societies often refuse to reappraise their core values. So same thing is kind of at work when you have ethical dilemmas. Your intent. Do any of you set out each day with an intent to be ethical rather than have it be a happy accident? Challenges. Most of us have not really had our professional ethics challenged. And then preparation. Have you thought about and planned for how to react when it does happen to you? So a little bit about morals versus ethics, because a lot of people tend to think they're one and the same. But personal morals are generally defined as your own private belief system. It's not a legal requirement to have personal morals. Oftentimes people attribute it to knowing the difference between right and wrong. It could be based in religion, could be based on societal customs, and generally they're thought to benefit the greater good, sometimes not. But professional ethics, you cannot rely solely on your personal moral right or wrong. They have to be congruent with your industry, and they require you to analyze all the values and perspectives of those involved, regardless of the moral issues. So they also require you to act in the best interest of those you serve. So your clients or customers, your employer, perhaps even regulatory authorities. So when you're looking at ethical decision-making, we generally start with trying to identify, yes? Was there a question? Okay. We generally start with trying to define the problem. What are the facts? What information do you need to properly assess the situation that is calling your ethics into question? And then we like to try to sit down and identify a list of possible solutions and think about what are the potential impacts of each of those solutions on the individuals, the communities, the organizations, all of those people that you need to take into consideration. And then you think about possible outcomes. All right, so here's the solutions, here's the impacts. What are the potential consequences for each of these solutions? And what values are we respecting or violating with these outcomes? We also have to consider harm. It can be something as simple as publicity, it can be negative or positive publicity, but we also have to think about defensibility. Could I actually defend my choice? Oftentimes I say, would I want to be on the witness stand and defend my decision in this manner, right? And then of course we have NIMBY, not in my backyard. And so that really translates to, would I still make this choice if it affected me instead of someone else? And then we always have the, can I live with my decision? And then we may actually garner opinions. What would my colleagues think? What would my profession or my licensing body say? What would my organization say? And so one of the things that we find is something called an intensity model. And so it really kind of helps us work through the perceived relevance or importance of an ethical issue. So first we have to start at the top here with the consensus that the action is actually wrong. And then we would go into how likely is that action to cause harm? Is the harm immediate? Because humans are pretty good at immediate harm, but we're pretty bad at long-term consequences. You put your hand on a hot stove and it's hot and it burns you, that's an immediate consequence. You say, I'm not going to do that again. But many people are really bad at long-term consequences, say, of smoking. I smoke a cigarette, I have no immediate negative impact. I know that harm may happen decades down the road, but the harm's not immediate, so I'm going to proceed. The next thing in the intensity issue is proximity to victims. Is it my family that's affected, or is it somebody halfway around the world that I've never met? One of the other things that we take into consideration is how concentrated is the effect. Is it only going to affect a few individuals that are spread out, or is it going to affect an entire community? So the concentration of the effect. And we use all of that to try to identify finally how much harm is there in this situation. And so all of these decisions are influenced by our personal values, our family values, our religion, our corporate values or policies, any existing reward or punishment systems, and ultimately our legal system. So when we talk about ethics, it can get really complicated really quickly. And so I like to then kind of switch over and talk about ethics in governments a bit. In democracies, governments are said to govern by the consent of the governed. So this requires a reasonable level of public trust for the representation in government. The degree to which the public is prepared to trust government is strongly influenced by the perceptions of the general ethical standards of that government. The public's perception as to whether or not a government is ethical is therefore central to whether that government is seen as acceptable. So we have ethics requirements at the federal and state levels, as well as for each state agency's licensees. And that's really where this ethics requirement comes from. So TBPG's purpose is to protect the health and safety of people and the environment. And we are required by state statute to have a code of professional conduct for our licensees. So when you look at our regulations, if you start at 851.101 subchapter C, that is the code of professional conduct. It is binding on all of our license holders. TBPG can impose sanctions for violations of this code. PGs and GITs are responsible for understanding and complying with the Act, the TBPG rules, and any other law or rule pertaining to the practice of professional geoscience. But it's really important to note that our Code of Professional Conduct does not define a standard of care. So the following is what I like to call the highlights reel, or my summary of this section of the rules. But as always, if there's a conflict between what I say in the slides and the rules, of course, the rules win out. So just the overview, we've got section 102 through 113, and I'll run through these fairly quickly with you guys. So 851.102 is competence negligence. So a PG or a firm shall be qualified by education and or experience in the specific technical areas involved. You must apply the knowledge and skill which is ordinarily applied by reasonably prudent professional geoscientists practicing under similar circumstances and conditions. So you can see, those of you that are familiar with setting a professional standard in the liability insurance realm, this same language is what we use in our rules. So we are not setting a professional standard any different than what your liability insurance would cover. I would add, though, that signing and sealing work that you are unqualified for would be considered incompetence. For section 103, recklessness. A PG or firm shall not practice geoscience that is reasonably likely to result in the endangerment of the safety, health, or welfare of the public. That includes conscious disregard of substantial risk or failure to comply with regulations. Section 104 is dishonest practice. A PG, GIT, or firm shall not defraud, deceive, or create a misleading impression. That actually includes advertising, statements, or exaggerated claims. And further, a PG, GIT, or firm shall not directly or indirectly solicit, offer, give, or receive anything or any service of significant value. 105 is conflicts of interest. So a PG, GIT, or firm, if you have any business association or financial interest which might reasonably appear to influence your judgment, you shall inform the client or the employer in writing. You will obtain your client's written consent to continue the work, or you will terminate either the work or the business association or financial interest. Further, a PG, GIT, or firm shall not solicit or accept any financial or other valuable consideration from more than one party in connection with a single project, unless it's fully disclosed in writing to all parties. And this would include suppliers, contractors, and consultants. 106, the responsibility to the regulation of geoscience profession and public protection. So a PG, GIT, or firm shall protect the public and shall not knowingly participate in any plan to violate the act or the rules of TBPG, aid or abet unlicensed practice, or fail to prevent his or her partners, associates, shareholders, or employees from violating the provisions of the TBPG rules. The PG shall be responsible and accountable for the use of his or her seal, professional signature, and other professional identification. So if lost, you must immediately report it to TBPG. Further, a PG, GIT, or firm has an obligation to protect the public health and report known or suspected violations to TBPG. A PG or firm shall keep adequate records of geoscience services provided to the public for no less than 5 years. And that includes signed and sealed documents and supporting documentation, descriptions of offered geoscience services, and billing, payment, and financial communications. A PG, GIT, or firm must examine the environmental impact of their actions and projects, including the prudent use and conservation of resources and energy. 107, the prevention of unauthorized practice. A PG, GIT, or firm shall not practice in another jurisdiction with a law regulating the practice of geoscience in that jurisdiction. If a PG or firm fails to renew his or her license or registration prior to its annual expiration date, you shall not use the title professional geoscientist or the initials PG. You shall not offer to or engage in the public practice of professional geoscience until after the license has been properly renewed. For GITs, you can't use GIT or geoscientist in training until you're properly renewed. 108, criminal convictions. So we adhere to and have no separate rules from the Texas Occupations Code, Chapter 53, regarding criminal convictions and licensure. We have the ability to suspend or revoke a license or deny a licensure due to a conviction. Licenses are automatically revoked upon felony incarceration. And any license holder whose license has been revoked under the provisions of TOC 53 due to incarceration may apply for a new license upon release. 109, substance abuse. If a PG's abuse of alcohol or a controlled substance contributed to a violation of the act or the rules, then TBPG may require the PG's completion of a rehabilitation program approved by the Department of State Health Services. A PG's abuse of alcohol or a controlled substance may be deemed gross incompetency, and the TBPG may order an examination by one or more licensed healthcare providers that diagnose or treat substance abuse. 110, effective enforcement proceedings. In accordance with our statute 1002-401B, the TBPG may not issue a license pending the disposition of a complaint alleging a violation in Texas or another state if TBPG has notice of that alleged violation in that other state. Pardon me, I've been sick for 2 weeks, so I'm sorry about the coughing. Section 111, maintaining confidentiality of clients. A PG, GIT, or firm may reveal confidences and private information only with a fully informed client's or employer's consent, or when required by law, rule, or court order, or when those confidences, if left undisclosed, would constitute a threat to health, safety, or welfare of the public. 112, required reports to TBPG. A PG, GIT, or firm shall make written reports to the TBPG office within 30 days of the following: a change in the firm's name, the authorized agent, the firm's owners, officers, directors, PGs employed by the firm, PGs who serve as the PG in responsible charge for the firm or branch offices, phone numbers, etc. Changes in a PG or GIT's mailing address or other contact information, or any other changes in employment status. A criminal conviction, that does not include misdemeanors or traffic offenses, right? Criminal conviction of a PG or a GIT. A civil settlement or judgment for a PG or a firm relating to professional geoscience services, or final disciplinary or enforcement actions against a PG, GIT, or firm taken by a licensing or certification body related to the practice of professional geoscience. So failure to make these required reports is grounds for disciplinary action by TBPG. And the last one, 113, duty to abide by board orders and timely pay administrative penalties. So failure to abide by the terms of a board order is grounds for further disciplinary action. All administrative penalties must be paid in 30 days. Failure to timely pay an administrative penalty is grounds for additional disciplinary action. The board can deny a person's request for a license, registration, certification, or renewal if you have failed to pay timely. Or when you pay money to TBPG, we're going to first apply that money to any outstanding administrative penalties before applying it to any renewal fee or other cost. So with that, I thought I'd run through a little bit of current licensing data, and then I have a number of case studies, but I can present those, or if we just use them to spur some questions and discussion, I'm happy with that as well. So our current licensing data through the end of December of 21, we have 3,277 licensed Texas PGs. 2,943 of those are geology, 238 are geophysics, 96 are soil science. We have 214 geoscientists in training and 334 registered firms. I just got an update from the soil science exam pass rates. This is an average for the last 4 years. So the fundamentals pass rate for the soil science exam in Texas is 32%, while the national is 49%. And the professional practice in Texas is only 17% pass rate, but the national is only 32%. For ASBOG, for geology discipline, these are the numbers from the October exam. Fundamentals pass rate in Texas was 54% as compared to the national at 65%. And professional practice was 68% compared to the national at 78%. But what I really want to talk to you about is the trend in licensing numbers. And as you can see, we are trending downward in total numbers of licensees, both total and individual PGs. The good news is that GIT numbers are showing a slight upward trend. But out of the 3,277 that we currently have, 937 are over 65 years of age. 2,116 are over 55 years of age. That means of all of our licensees, only 1,161 are under 55. So it's crucial that we be talking to the young professionals, the students that are still in school, talking to them about licensure, about getting on track to pursue their license in any of the 3 disciplines, so that we can get them on that path to licensure as the rest of us with all of this lovely gray hair are getting ready to retire. I do have a little bit of breaking news for you guys. We had published suggested changes to firm registration, and last Friday, the board voted to adopt these changes. So the proposed changes were posted to the Texas Register, and all we received were positive comments on the change. So we've now adopted this. So previously, firm registration requirements were tied to the Texas Comptroller's definition of sole proprietor. And by definition, a sole proprietor could not be incorporated. So we have changed that terminology to sole practitioner, because we did not feel that incorporation status was within our purview. So now, if you're the only PG employed by the company, you can operate under your PG license without a firm registration. But if you hire, whether full-time, part-time, or on a contract basis, another PG, then you must register as a firm. This is eliminating what some felt was a double payment for that sole practitioner out there, having to have both the PG and the firm registration. And so we hope that this change is reflective of the comments and things that have been submitted to us over the last couple of years. So I'm really happy about this change, and I hope that you guys like this change as well. And with that, I've got some case studies. I'll throw a few out here, and feel free to interrupt me or ask questions or bring up a situation that you have seen. So these are mostly things that we've been seeing at TBPG. This case was a firm that renewed a deceased PG's license 10 times between 2009 and 2018. So they failed to provide a written report to TBPG that the PG had passed away, or that they had changed the PG that was in responsible charge for the firm. And in total, the assessed penalty was $60,000. We have seen a lot of geoscience reports going out without firm registration information included. We have seen as many as 50 geoscience reports that have gone out without that firm registration information. In one of these instances, this was reported to TBPG by a third-party reviewer. And when we went back to that firm, they identified as many as 50 reports they had issued during 1 year when actually they were unlicensed as a firm. So the PG that was signing these reports was actually in violation of aiding and abetting a business entity in the unregistered practice of geoscience and failing to provide the required firm registration number on sealed reports. So we assessed the firm and the PG each $1,000 administrative penalty. We've seen an awful lot of failure to sign phase 2 reports. We had one instance where a PG had issued as many as 500 unsealed phase 2 reports. When notified, the PG said that they only signed reports that were submitted to TCEQ. And so they gave us the estimate of about 500 reports that they had done unsealed. And as we talked to them, their confusion was that they thought doing work for private clients did not constitute the public practice of geoscience. So we want to make sure everybody's really clear. If you're doing work for a private client, that is still the public practice of geoscience. And that one was a $5,000 penalty to cover all of those 500 unsealed reports.
Becky, I have a question on that.
Yeah.
So some areas of practice are not regulated. And I'll give you the example of the oil business and also archaeology. So if we do work for, say, an archaeological survey, do we have to seal it? It's not required. And do we have to declare that we're a PG while we're doing it?
Are you doing geoscience or archaeology?
This would be a geoscience survey. It would be a ground penetrating radar survey.
Okay, so generally what I would say is just, I believe the way most of our geophysics folks interpret this is going out and doing the survey. You don't have to be licensed to do that work. But if you do interpretation of the results of that survey, then that would be considered geoscience. And so those interpretations should be signed and sealed. But you do not have to take responsible charge of the entire archaeology work because that's not part of the licensed practice. It would only be the interpretation of the geoscience work. Does that make sense?
It does, but it's contrary to what I've experienced recently. Okay.
Might I suggest that you forward us a couple of examples and we can put it into discussion and make sure that we are—
Sure, I'll pass it up to Molly.
Yeah, I'd love to make sure that we're getting everybody the same information.
Okay, thank you.
Yeah, you bet. Any other questions on that one? Okay. Another one that we had was misappropriation of funds by a treasurer for a professional society. In this instance, the treasurer borrowed some funds that were used for personal expenditures. When the professional society confronted their treasurer, they also reported it to us. But the complainant's primary objective was to secure repayment of the funds, and therefore they did not notify the police and they didn't file any criminal charges. So as you saw in our requirements for criminal convictions, we're limited in what we can do if there's a criminal conviction and subsequent incarceration. But because there were no criminal charges filed, we had the opportunity to work with both the licensee and the complainant to arrive at some conditions on the licensee that would ensure repayment of those funds. And that was specifically at the request of the complainant. So that was a very interesting one for us. And because there were no criminal charges filed, it gave us a broader range of options of sanctions that we could impose. We've seen an awful lot of geoscience reports that are not signed and sealed at all. We're seeing a big increase in that. Again, mostly this misconception about private clients not being the public practice of geoscience. But a lot of these are coming into TCEQ, and we have a pretty strong working relationship with TCEQ and specifically the PG work group at TCEQ. And so we're seeing a lot of these referrals come from TCEQ at this point, or from other third-party reviewers. When we open the complaints, the respondent generally says, oh, I didn't know, or I thought private clients weren't public practice. And so really important that the licensees really know and follow the rules that apply to them. We've seen quite a bit of geoscience work being done under a PE firm that's not signed and sealed. So a number of the reports we've been seeing, it comes from a PE firm, but they're not signed and sealed by either the PE or the PG. For some of these complaints, no PE was going to seal it because it was geoscience work and they weren't qualified to seal it. And that really means that a PG needed to seal the work. In other instances, it turns out that the PG had left the firm before the reports were issued and no one else would take responsible charge of the work, so they just submitted it without a seal on it. So still others were under the impression that doing geoscience for a PE firm meant that no seal was required. So just to be clear, PE firms do not have to also register as a geoscience firm, but the PG still has to sign and seal the work, and they have to put the PE firm registration information on the report. We see a lot of PG license renewals without continuing education. As you know, when you go in and renew it online, you check a box that says that you did your continuing ed. But we are required by statute to actually audit a certain percentage of the renewals each month. And so we send out an audit request asking you to provide the documentation that proves you got your CEs done. And so what happens is when they're audited, they can't provide the proof. When this happens, it's not just one violation, but it winds up being 4 separate violations with a fine of up to $500 per violation per day. And of course, once a violation is issued, it's a public posting on our webpage. We are required by statute to post all violations on our webpage. This one was really interesting. We had misuse of a draft report. So we received a complaint from another state agency that the original author's work had been used without permission in a permit application. Unfortunately, in the end, we had no jurisdiction on this because TBPG rules weren't violated. There's no requirement to sign or seal draft work. And so there was no way for TBPG to then say, well, that draft work is under the purview of TBPG. But I throw this one out here as a warning. The draft work was taken, the name was changed, some additional work was done, and then it was submitted under somebody else's name for a permit application. And so just a word of caution, protect your drafts. You might not have considered the importance of protecting your draft materials, perhaps watermarking every page of the draft plan or report, adding a phrase like "do not use without PG signature and seal." If you can submit a draft in a lockdown PDF version that doesn't allow editing or copying, and make sure that your contracts clearly state who has ownership of all draft work products. This one was a difficult one for us. I know how upset I would be if my draft work were taken and used in this manner, but because there was no sign and seal involved, TBPG didn't have any jurisdiction on it. We've seen one where somebody intentionally selected inappropriate sample locations. They collected soil samples, but they were in areas that were likely not to show any impacts. So in this one, somebody reviewed a phase 2 that showed no impacts and recommended no further assessment, but the site had been a gas station for over 50 years. And then they discovered in reviewing the report that the sample locations and the depths reported in the body of the report didn't match the sample depths on the lab report in the appendix. So this reviewer was quite thorough and found that all the soil samples had been collected at 2 feet below ground surface and couldn't be representative of site conditions. So the third-party reviewer rejected the phase 2, but the question is, do you report that breach of ethics to TCEQ and to TBPG? And my answer on that is yes. When in doubt, always send it to us. If we find or determine that we don't have jurisdiction, it doesn't go any further. But in situations like this, if we don't know about it, we can't take action. We had another situation where someone's boss told them to withhold information from a regulatory agency. TCEQ requested all data for a specific compliance issue, and then the boss said, no, you send them this and this, but don't send them all this other information over here, but you're going to send the letter that says this is all the information we have. So that's a huge problem, and one that can really challenge your professional ethics. And so what do you do with that? If you're having correspondence with TCEQ and it's your obligation to report everything per their request, but then you're told not to, how do you handle that? And TBPG can often intervene in those situations and show that you have an obligation to report. This one's coming up more and more with us, practicing outside your field. As you know, if you're licensed in geology, our license says you can practice geophysics or you can practice soil science, provided that you're competent and qualified in those other disciplines, right? So the requirement is that you're competent through education and or experience to practice in those different disciplines. And one of the questions that's been coming up lately is, well, how much experience does that take? If I got my license in geology, how much geophysics do I have to do to be qualified in that? And that is actually a question that we're grappling with right now. So right now we are looking at the experience requirements for waivers of the exams. So you have to meet either the generalized or the special practice experience, which for generalized, it's 20 years of geoscience work, 10 years of supervisory experience, and coursework in 6 of the 8 ASBOG domains, or 20 years or more of specialized work history in 1 or 2 of those task domains. And we do now have waivers in place for, or we're almost in place for the geophysics exams. And I believe we have waivers in place now for the soil science professional practice exams. So things are changing rapidly in this area, but this is a question that we're looking at right now to see how much experience do you actually have to practice outside your discipline. So if any of you guys have input on that, please email me your thoughts. I'll be happy to take those into consideration. I'm sort of leading the charge on this one, so please give me your comments. And the last one I have for you tonight is plagiarism. Scientists often build on work done by others, but we really need to give credit where credit is due. Plagiarism happens when somebody presents somebody else's designs, words, codes, ideas, etc., as their own. Being a college professor, I see this a lot. Oftentimes, though, that gets taken a step further and it can be misrepresentation or exploitation, and that can result in lawsuits. I've had a couple of inquiries recently about what happens when a PG's maps, boring logs, reports, etc., are incorporated into someone else's report. And my question back is always, was the work properly cited and referenced? Further, was the work modified? Did anybody take that information, modify it? And if so, did someone take responsible charge of those modifications? I am getting some interesting answers back on those questions that I've asked. One of the other questions that I ask, having been a consultant for so many years, is, did the author include it simply for convenience, or did they rely on it for their own conclusions and recommendations? So it's a bigger and bigger issue, especially when you are working on a project that's been ongoing for 5, 7, 8 years, right? It's likely that somebody started the work, now you've taken over the work, and how do we make sure that we are taking responsible charge of the work we do and not misusing previous work. I just did a workshop for TCEQ on last week, and this was one of the questions that comes up a lot with site investigations and borings and things that were done prior to the existence of TBPG and the requirement to sign and seal work. And how do we incorporate that work, use that data, but not take responsible charge for it? So it's a fine line to walk, for sure. I do have a request for you. The other thing that I would like to do this year is to create sort of a repository of knowledge for our younger licensees. I'm really asking each of you to send me your stories, large or small, about how your practice protected the public or how someone else's poor practice endangered the public. Could be about a corner gas station that threatened a water well, a soil amendment that killed a crop, or a voodoo geophysics that caused an unrecoverable financial loss. The engineers do a really great job of having this compilation of experiences and mistakes and problems that really help to educate their young engineers in training and get them ready to be in professional practice. And I really want to create that knowledge base before I leave the agency. And so I really think this is a crucial mechanism for communicating what it is we do. And I think it will help us tremendously in the next sunset if we have some of this work compiled. Because I know that many of you understand that when you talk to people outside of the geosciences and you tell them what you do, when you say, oh, I'm a geoscientist, they go, oh. And that's about all they have to say, right? Because they don't really understand what it is you do. And so I know that each and every one of you has a story that needs to be told. So please, I'm asking you to send me your stories. You can scrub client names. You can scrub out addresses. You can make it as anonymous as it needs to be. But the key is really telling the story of how what we do as licensed geoscientists matters. So please send us your stories. And with that, mailing address, contact information, and then some direct contact information, depending on different topics. And if you would like to email me your stories or email me about anything, my email address, bjohnson@tbpg.texas.gov.